Joining me now, my first guest tonight, Vishnu Jain, lawyer in the Gyanvapi case for the Hindu petitioners. Appreciate your joining us, Mr. Jain. Now, the controversy today comes over the entire issue of videography of the survey and the manner in which the findings were leaked in advance that there was a shivling there. You could have gone to the court, you have gone to the court based on that leak report. Now the court commissioner is removed. Questions will be raised. Is this entire survey been done to prejudice, in a way, the court proceedings with the leakage of this report?
No, there is no question of any leaking of the report. Yesterday, when the survey was being conducted and the moment the survey got over, my clients and the plaintiffs, they saw the shivling, and we felt, and our legal team felt that there's an immediate need for protection orders. And therefore, as per Order 39, Rule 1 of the CPC, there is a provision under Order 39, Rule 1 of the CPC that if there is a danger of destruction of the suit property, then immediate interim relief can be granted ex parte. So therefore, in light of the provisions of Order 39, Rule 1 of the CPC, we approached the Honorable Varanasi Civil Court and we immediately requested the Varanasi Civil Court that since it is a very important piece of evidence for proper adjudication of the matter in issue, therefore, this shivling which we have found in the Vaju Khana must be protected and must be preserved, must be sealed. And that order was passed by the Honorable Varanasi Court, and the said order has been maintained by the Honorable Supreme Court today.
Mr. Jain, today the Varanasi Court has removed the court commissioner. And the argument being made is that the court commissioner leaked confidential findings by hiring a private cameraman, and the petitioners, instead of maintaining the confidentiality of the report, went ahead, made it public that there was a shivling out there, thereby prejudicing the case. What happens to the confidentiality of the court hearings on a sensitive manner, Mr. Jain?
No, it is absolutely wrong. It's a total misrepresentation of the order. Kindly read the order which has been passed today. The ground of removal of the Advocate Commissioner is that the Advocate Commissioner, Mr. Ajay Mishra, had taken one private person, Mr. R.P. Singh, along with him in this entire survey process. And after he came out of the survey, he briefed the media about whatever he saw in the survey. And therefore, on giving media bites and giving media interviews with regard to the survey which was happening, Mr. Ajay Kumar Mishra has been removed. There is no question of, there is no involvement of the plaintiffs in this, and nothing like that. What you are just saying is mentioned in the order.
The charge, in a way, Mr. Jain, that you will have to address at some stage is the attempt that is being made through the media to influence the verdict even before a report on a sensitive matter is submitted and made public. That you are conducting a media trial on Gyanvapi Mosque by claiming that there was the shivling there.
See, there is no question of prejudicing anyone. The lawyers and the legal team of this entire case, they have not even uttered a single word so far as this entire survey is concerned. And those who have uttered those who have briefed the media about whatever survey is going on, they have been, strict action has been taken against them. And they are not the plaintiffs of the case. All our 5 plaintiffs have said nothing about the survey which has been conducted. And apart from that, no lawyer of the case has spoken anything about the survey. I myself have not spoken anything about the survey. And only the aspect of shivling I have spoken because we have filed an affidavit in the court. We have moved the court seeking urgent interim relief for protection of the shivling. Therefore, when the court passed that order, then briefing was done, and that was not with regard to the survey. Whatever we found in the survey, nothing has been told by the legal team or by the plaintiffs.
The larger question, Mr. Vishnu Jain, is whether the survey per se is a violation of the Places of Worship Act, which says status quo must be maintained on all places of worship as they stood in 1947. The petitioners who've gone to the Supreme Court claim that the Act protects the religious character of the place and says therefore conducting the survey was ab initio illegal, aiming to change the character of the place of worship. How do you respond? Because this is now also going to become critical in the Supreme Court, which is hearing the constitutionality of the survey per se.
It is absolutely erroneous and a misplaced argument. Because if you analyze this entire matter, this objection was taken by them on 5th of April. The Honorable Trial Court had clearly mentioned that right now we are not going to change the nature of the property. If one side is claiming that this is a temple and the other side is claiming that this is a mosque, then first we have to ascertain that what is the religious character of the property in question, and then only there will be any further question or issue with regard to attraction of places of worship act. When this preliminary question has not been decided, you have assumed, the Muslims have assumed that this is a mosque. Since they offer namaz, this is a mosque forever, and they want to shut the voice of the masses of this country who are saying, who are showing proof that there is a huge Hindu structure beneath this mosque. So the question is, Rajdeep, that if two sides are claiming on a particular issue, first that issue has to be adjudicated, and after adjudication of the issue, the attraction and the question of places of worship act will arise. Because if you will look into it very minutely and deeply, Section 4 subclause 2 of the Places of Worship Act uses the word religious character. And the religious character which was existing on 15th August 1947 has to be determined first. Then only places of worship can be attracted. Now the problem is that the entire Muslims and the Anjuman Intizamiya is shying away and running from the survey because they know that what is the religious character of this property in question. I am ready to put in evidence. I am ready to prove my case through evidence. But the question is, what's the fear? Why Anjuman Intizamiya is so fearful to enter into trial? They just want the protection of a parliamentary law. And ultimately, Rajiv, just see this entire issue on a holistic point of view. Ultimately, what are you seeking for? You want to shut the doors of the court for us? If we are saying that this is a temple, you say that no, boss, you cannot say that this is a temple because Places of Worship Act restricts you. So you can't go to the court. Okay, if I can't go to the court, then where should I go? I'll go to the parliamentarians then. I'll ask the parliament and the officers in charge in the helm of the affairs of this country to enact a law and declare Kashi Vishwanath to be a Hindu temple. Then the question will be, will you abide by that? That will also be a law passed by the parliament. So the question is that if two communities are saying that there is a dispute at a particular place, the only forum by which it can be adjudicated is a judicial process. And you cannot say that you cannot have a judicial remedy at all. What Mr. Owaisi and other leaders and Anjuman Intizamiya are asking and seeking and asking this question is that no, you will not have a judicial remedy. No case in the court will be filed. Just shut your mouth and keep mum. That cannot be done.